We are on the record, Your Honor.
Thank you. Good morning, everyone. Welcome to the appellate court. We are conducting the argument this morning in State versus Turner. Docket number is 44806 over the Teams platform. So everyone is appearing virtually through video conferencing. I'm going to ask everybody, starting with the judges, then the appellant, then counsel for the appellee, to identify themselves for the record to make sure we can all hear each other and see each other okay. I'm Judge Bright.
I'm Judge Elgo. I'm Judge Cradle.
The defendant, Corey Turner.
We cannot hear you, Attorney Luke Bond.
Your Honor, can you hear us now?
Yes.
Right, thank you. I apologize.
Can you just identify yourself, please?
My apologies, Your Honor. Technology flusters me. Michelle Lookbon with the Appellate Bureau of the Office of the Chief State's Attorney.
And well, who's going to be can you identify who's going to be arguing?
I'm sorry, Your Honor. With me today is Mr. Jordan Levin. Mr. Levin is a certified legal intern, and he is representing the state this morning.
Thank you. Okay, so we're off to a little bit of a rocky start, but hopefully we'll go smoothly from this point forward. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will keep the time, and I will, because we don't have the light system when we do the virtual, I will hold up signs at 2 minutes, at 1 minute, and when time is up. So I'm going to ask everyone when they are not speaking to mute their microphone if possible, so that we can avoid any background noises. And I would ask I'm hearing clicking or typing noise that I think is coming from the DOC feed. I don't know if there's someone in the room with you, Mr. Turner, who is typing on a computer, but I would ask that person, if that is happening, that they not do that.
It's the air conditioning duct above me, Your Honor, is making a rattling noise.
Oh, okay. All right. I can't do anything about that. I'm not going to have them turn off the air conditioning. But it sounded like someone on a computer screen, on a computer keyboard. Yeah. So, okay. So I think we're ready to proceed. Mr. Turner, you ready to go?
I am, Your Honor.
All right. And how much time would you like to reserve for rebuttal?
5 minutes. While I doubt I'll use the full 15, but 5 minutes will be good.
Okay. All right. Whatever else you don't use, you'll be able to reserve for rebuttal as well. So you may proceed. Just identify yourself and then go ahead.
All right. Corey Turner, self-represented party, the defendant in the matter. And may it please the court, the defendant is asking that the court reverse the decision of the trial court for 2 reasons. The first reason is that the trial court improperly characterized the claims raised by the defendant in his amended motion to correct an illegal sentence as a Miller argument. The characterizing the argument as a Miller claim and suggesting that the defendant was attempting to raise the bar north of the demarcation mark established by the Miller line of cases. That's not the case here. The defendant explicitly in his motion and during his arguments before the court raised a due process claim, alleging that the trial court made a materially false assumption concerning his rehabilitative capacity, and the defendant sought to present expert testimony to substantiate his claim and to serve as evidence that that assumption was false. And I think that there's a clear debate amongst jurors of reasons. In particular, on January 14th, 2020, Judge Boldini afforded the defendant an opportunity to have a full evidentiary hearing on his claims. However, There was a pandemic, as Your Honor is aware, as evidenced by us having this hearing through video conference, that prevented that hearing for taking place on July 13, 2020 as scheduled. Subsequently, Judge Graham was appointed and stepped in the matter and sent notice that there would be a hearing. And during that hearing, I would be given the opportunity to convince the judge essentially that expert testimony would be necessary. And it's my position that that wasn't a full hearing. That wasn't a hearing that would enable me to fully address and flush out my claim because it's based on the science. And so in the light of the fact that defendant raised no Eighth Amendment claim, defendant did not claim at any time that he was entitled to have his age and the hallmarks of youth considered prior to sentencing, directly or indirectly, that it was improper for the judge to characterize his claim as a Miller argument. The second reason why I believe that the court should reverse the trial court's decision is that this court decision in Miller should control. And just quoting what the court stated in Miller, I think is salient here, is that in order to preserve this novel claim, including any subsequent appellate review, the defendant in the present case was entitled to make an evidentiary record of any facts that would be relevant to it, including any underlying brain science that would justify, in this case, justify a finding that the trial court, the sentencing court, assumptions or opinion concerning my future rehabilitative prospects was based on a false opinion. And basically, that's the position I assume below, and it's the position I assume here with Your Honors today. And essentially, if you have no questions of me, that's my position.
I guess I had just one question for you, Mr. Turner. Is it your position that anytime a judge sentences someone who is between the ages of 18 and 21, that judge cannot rely on their past conduct, including criminal conduct, in determining whether rehabilitation is appropriate?
No, sir, that's not my position. The judge is free to do so. And that's clear. The law is clear on that. My position is this. The judge explicitly stated that your criminal record is not the worst I've ever seen, but it indicates poor rehabilitative prospects. It's my position that the opinion that my record was somehow an indicator of future rehabilitative prospects was a false opinion, and that expert testimony would demonstrate that that opinion was false. But to answer your question, that's not my position. A judge can consider a whole host of things in fashioning a sentence, as the law is clear on that.
So is it your position then that anytime a judge is sentencing someone who's between the ages of 18 and 21, the judge can't consider the past record as an indicator of the effectiveness of rehabilitative efforts?
I'm not saying that the judge cannot consider that. What I'm saying is, in this particular case, that my criminal record was not an indication of who I would be 25 years later, after the young man that was standing in front of the court at that time, that the court could not accurately make that determination based on my record.
Based on your particular record in this particular case?
Absolutely.
Okay. All right. I don't see any other questions. So you used 5 minutes, so you'll have 15 minutes if you need it for rebuttal.
Thank you.
We'll now hear from the state.
Good morning, Your Honors. May it please the court. I am Assistant State's Attorney Michelle Luke-Bond with the Appellate Bureau. With me today is Mr. Jordan Levin. Mr. Levin is a certified legal intern and is representing the state in this matter. Thank you.
Good morning, Your Honors. May it please the court. My name is Jordan Levin, certified legal intern representing the state of Connecticut in this matter. This court should uphold the trial court's ruling for two reasons. First, consistent with this court's decision in Mukhtar, the trial court properly concluded that it did not have jurisdiction over the defendant's claim because the claim relies on and raises the underlying rationale of Miller, which does not extend to a defendant that is 18 or over at the time of the crime for which he was being sentenced. Second, and alternatively, if this court determines the trial court does have jurisdiction over the defendant's claim. The trial court properly determined that the sentencing court had not relied on any factually inaccurate information, nor drew any assumptions based on factually inaccurate information when imposing sentence. On the first issue, the issue of jurisdiction, the trial court identified it did not have jurisdiction for 3 reasons. First, the trial court properly determined that the defendant was raising a Miller claim by invoking Miller's underlying rationale. And consistent with this court's decision in Mukhtar, there is no jurisdiction in such a claim. Second, the defendant repeatedly claims that he is not making a Miller claim, but instead raises a separate due process claim, which asserts that the sentencing court did not consider the brain science and mitigating factors which underlie Miller.
Counsel, question just procedurally. The transcript reflects that the court said it was dismissing the claim and made clear that it was using that language specifically. The judgment file indicates that the motion was denied. The court never, at least as I could tell reading through the transcript, refers to subject matter jurisdiction. Is it your position that the court dismissed the claim as opposed to denying it?
It is, yes.
And what's your basis for saying that the court dismissed it based on subject matter jurisdiction?
In the defendant's appendix at 824 to 825, the trial court makes clear that the court is dismissing the claim and puts it, and highlights the term dismisses as opposed to denying the defendant's claim.
I understand that, but my question is, what's your basis for concluding that the dismissal was based on lack of subject matter jurisdiction?
So in the state's response to the defendant's motion to correct or amended motion to correct, the state highlights State v. Hockey and State versus Mukhtar, where it was determined that the trial court does not have jurisdiction to hear a claim that relies on Miller or the underlying rationale of Miller when the defendant was 18 years or older at the time of the crime, which was being sentenced. So, and in the A25 in the defendant's appendix, the trial court cites U.S. versus Sierra, which is a federal case which also stands for the same proposition.
Okay, thank you.
The defendant raises a separate due process claim, which relies on the underlying rationale of Miller, but there is no separate legal analysis when a constitutional claim asserted is subsumed or covered by a specific provision of the Constitution, in this case, the Eighth Amendment. And the third reason why the trial court correctly identified that it lacked jurisdiction was that because the trial court are also consistent with this court's decision in Mukhtar, the trial court properly rejected the defendant's request for an expert witness to present expert testimony to speak on the mitigating factors of youth that underlie Miller. In the alternative, if this court determines that the trial court does have jurisdiction, there are 2 reasons why the trial court properly determined that the defendant failed to identify any factual inaccuracies which the sentencing court relied upon, or that it drew assumptions based on factual inaccuracies. The first reason is that factually inaccurate information is the necessary predicate to an argument which asserts that the sentencing court made a materially false assumption. The defendant concedes that his criminal record does not contain inaccurate information, nor has he brought anything before this court to this court's attention which shows that the sentencing court relied on inaccurate information, or that the sentencing court formed an assumption or an inference based on inaccurate information.
Counsel, did the Supreme Court reject the same argument the state that you're making by the state in Belcher?
No. This case is distinguishable from Belcher in several ways. So the sentencing judge, the sentencing court in Belcher drew conclusions based on the super predator theory, based on this general theory of juvenile criminality, and then imposed those now debunked theories on the defendant in imposing sentence. Whereas here, the facts in which the sentencing court relied upon were all particularized and individualized to the defendant and the defendant's record. So, in regard to the false theory, or in regard to relying on factually inaccurate information, that category of sentence imposed in an illegal manner, the defendant's record, as presented before the sentencing court, showed a pattern of criminal behavior as an adult as well. So to the extent that the defendant seeks an expert witness to speak on the brain science or transient immaturity that underlies Miller, the sentencing court had before it a record which negated the conclusion that the defendant's record was a result of transient immaturity or youthful indiscretion. The second reason why the trial court properly determined that the defendant failed to identify any factual inaccuracies is that it noted that the defendant's motion to correct highlights one factor, the defendant's criminal record, to the exclusion of other important factors which the sentencing court considered when imposing sentence. And there's really three factors that the sentencing court identified and that are within the sentencing transcript. First of which was the defendant's lack of remorse. Remorse is indicative of a readiness for rehabilitation, whereas lack of remorse can indicate the defendant is not ready for rehabilitation. Second was the defendant's overall criminal behavior. And the facts considered in this category was the defendant's criminal record, which from pages 8 to 9 of the defendant's brief, he concedes was not factually inaccurate. The sentencing court was aware also of a pending charge against the defendant, where the defendant was accused of hindering the prosecution in a separate pending case by hiding a suspected murder weapon. And also the defendant had accrued 5 disciplinary tickets while in custody pending sentencing in this case. And third, though not necessarily indicative of rehabilitative potential, the sentencing judge noted and spent time emphasizing the location and nature of the crime for which the defendant was being sentenced, which was a premeditated murder and assault by ambush on a populated street. The trial court considered these factors, considered the defendant's pleadings below, and heard the defendant at the motion to correct hearing, and within its discretion concluded that the sentencing court had not relied on inaccurate information. Now, in regard to this alternative argument, ultimately, were this court to conclude that the trial court had jurisdiction within the category of reliance on false information, a claim such as that, the trial court will be forced to conclude that there is no jurisdiction, because to understand a defendant's reliance on false information or reliance on a false theory claim, we necessarily have to import the underlying rationale of Miller, which, consistent with this court's decision in Mukhtar, is not possible. There is no jurisdiction in that. The reasons argued by the state today in its brief, and consistent with this court's decision in Mukhtar, The state respectfully requests that this court affirm the decision of the trial court dismissing the defendant's motion to correct. If there are no questions, thank you.
I see no questions. Thank you. Mr. Turner, you'll have up to 15 minutes for your rebuttal.
Thank you, Your Honor. I have a few things. First, Mukhtar doesn't apply here. There was no attempt by the defendant to elevate the level of the age level for juveniles or for defendants north of the age of 18. The defendant made it clear that he understood that there was a demarcation point of 18 where those matters was concerned, and it's the 8th Amendment argument of cruel and unusual punishment where the court is now required. And now even Connecticut, that's no longer a requirement because juveniles get parole. So at least individuals who was in prison prior to the announcements of those authorities after our state Supreme Court made it clear that going forward, because paroles are option, and that the court doesn't have to take those factors into consideration ahead of time. The defendant made no such claim. I did not claim that there was cruel and unusual for the court to give me a life sentence, that the court was required to consider the mitigating factors of Miller in those lines of cases prior to sentencing me. This is a due process claim, and it is consistent with our Supreme Court's decision in Belcher, where there was a false theory, as pointed out by counsel for the state, the super predator theory. And how was that theory debunked? Through empirical fact, research, and the government acknowledging that there was no science to support the proposition that young males can be characterized as super predators. It's my position that the facts, the evidence that would support my contention that the trial courts made a material false assumption when concluding that I can't be rehabilitated, that I should be incapacitated, was a materially false assumption. And it's not important science. The science existed before Miller and those lines of cases was decided by the U.S. Supreme Court. It's science. I don't think it can be pigeonholed to Miller unless it is attempted, as the state claimed, to be used to elevate the age level. That's not what I did. I don't think that my motion would lend any credence to that or the argument that I made before the trial court or this court today. My position is that the science would demonstrate that the court's assumption that my criminal record was an indicator that I should be incapacitated, that I'm irredeemable, was a false assumption. And barring a full hearing to flush that out and to have that evidence before the court in the record, the trial court below was not in a position to make that determination. And again, I will point out that Judge Bodini had scheduled the hearing to allow me the opportunity to present that science. And something changed along the way. I don't know what changed, and there was no indication that Judge Graham disagreed as far as a law of the case type scenario where there's some new or overriding circumstances, or that Judge Bodini was somehow wrong in scheduling the hearing.
Mr. Turner, when Judge Bodini scheduled the hearing, had you already retained expert witnesses on this subject?
My family was engaging a couple of folks to testify as experts that is known in the state, that to see what the cost would be and things of that nature, or to see if I would be required, if they couldn't afford it, to file forward through, I think is the Wayne case that allows the public defender's office to appropriate funds for indigent defendants to obtain expert testimony. But yes, it was an ongoing process to obtain expert testimony. And aside from that, Your Honor, again, there was no attempt to raise the level of to suggest somehow that I was entitled to the considerations that a juvenile would be given. And the suggestion, the claim that I made, and I don't expect this court nor the trial court, I don't think the trial court was in a position to speak to whether or not I would have been successful in establishing that science would demonstrate that the court's assumption was a false assumption. Just as this court pointed out in Miller, it expressed no opinion as to the merits of the defendant's novel claim. This is a novel claim. And I don't expect this court to express an opinion on it. I think that if this court determines that the court had jurisdiction, that this was a due process issue raised, that I should have been entitled to present testimony to substantiate my claim. And because the court deprived me of that opportunity, the decision should be reversed. And with that, if the court have no questions of me, I thank the court for its time and consideration in this matter.
I see no further questions. Thank you. Thank you both for the arguments. We will take the matter under advisement, and thank you for your patience this morning. We will stand in recess while we return to the courtroom to hear our last two cases of the morning. Have a good day, everyone.
Thank you, Your Honors.